Thank you everyone for joining us and good afternoon. We are here today for the presentation on planning ahead, the basics on power of attorneys, wills, and personal directives. My name is Leanne Taylor. I am a regional caregiver support coordinator for Caregivers Nova Scotia, covering Northern and Eastern Mainland. And the rest of the team at Caregivers Nova Scotia is on the line today with us. And my Executive Director, Jenny Theriault, will be helping with this presentation. At Caregivers Nova Scotia, we are a charitable nonprofit organization that helps family and friend caregivers with free services and education. We offer caregiver support groups throughout the province. They are available virtually and in French too. If you have any questions about the services we offer at Caregivers Nova Scotia, please reach out to us. We are happy to help. I want to thank Diana Burns from Legal Information Society for partnering with us today to bring you this presentation. Again, the presentation will be recorded, but at the end, when we be asking questions, that part will not be recorded. We do ask that all microphones are muted. And if you don't have an opportunity to ask your question today, please reach out to us at a later time and we'll be happy to help you with some of that information. I'm going to ask my coworker, Janine Wilson, the Regional Caregiver Support Coordinator for the Valley, to do the land acknowledgement.
Caregivers Nova Scotia acknowledges that we live and work in Mi'kma'ki, the ancestral and unceded lands of the Mi'kmaq people. This territory is governed by the treaties of peace and friendship. We are continually learning more about how to engage and move forward with the work of truth, reconciliation, and equity. We recognize that without action, an acknowledgement is empty. It marks the beginning of the work ahead of us, not the end. We are all treaty people.
Thank you, Janine. Now the floor is yours, Diana, and Jenny will be helping you with the slides. Thank you very much.
Hi, everybody. Thank you very much to Caregivers Nova Scotia for inviting us to have this chat today. We can pull up the slides while we're gay. Great. So the idea today is really to kind of go over some of the basics of what an estate plan would be. And when we reach the end of the presentation, I'm going to try to answer questions if you wanted to pop them into chat, or you can ask them. I think we'll have some time, as Leanne mentioned. And again, anything there's that we don't cover here of Nova Scotia, if there's anything of a specific legal nature, feel free to reach out. There's an email at the end for listens that you can reach out to, and a website address to go to legalinfo.org at that stage. So we'll see that at the end, I think. So if you want to take the next slide. This is really the overview of what is an estate plan. So some of you may or may not have estate plans already, or parts of an estate plan. When we're talking about an estate plan in Nova Scotia, a basic plan consists of a will, a power of attorney, and a personal directive. And so you'll see those three there in black, and then a blued out version of guardianship appointment mentioned. A guardianship appointment for a child is really focused on a specific piece of legislation for parents who want to name someone if something happened to them who would be able to act and care for their child. So it doesn't apply to everyone, whereas the first three apply to everybody. So I mentioned guardianship appointment. If you have people with children in your lives, in their lives, in your lives, guardianship appointments are really important. But the three main pieces we're talking about today are the wills, the powers of attorney, and personal directives. Next slide. So the first document, very likely you've dealt with these. We've all seen them on TV, wills and all the things associated with wills. Last will and testament. Will is really a document in Nova Scotia that provides someone authority to act and disposes of your things. So a will takes account of your entire estate and says, I want these people to inherit, and here are my things, and I want it done in this way. And so your estate is really your assets minus your liabilities. So if your estate includes assets like property, money, personal belongings, there's a lot of different ways you can use a will to detail those or to generally divide those things amongst your beneficiaries after all of your debts are paid out. So when we're talking about a will, we're talking about that hard copy document that appoints someone. Some people call it an executor, some people call it a personal representative, as it is in the legislation, to do things for you after you pass according to what you've written in your document. Next slide. So there are formal requirements for a will in Nova Scotia. A typical will require it be in writing, it be signed at the end, and that you sign it in front of 2 independent witnesses. So it's sort of like the 3 of you all together signing each page together at the bottom. The capacity issue is really a question of legal capacity. So we have to know what we're doing in order to write a will. We have to approve what's in it. So we need to know what's in the will. We need to approve what's in the will. But the formalities for a traditional sort of will, when we're thinking about a will and what's in the legislation, are related to those formal processes. So making sure that it's in writing, signed, and has those independent witnesses. There's another type of will we're going to talk about as well, but the idea is if someone's helping you do the will, there's going to be this formality that you have to meet. Next slide. Nova Scotia has LISNS, Legal Info Society of Nova Scotia, and it's one of these public legal free education groups in the country that's been working on a wills app. So LISNS is going to be launching this sort of question and answer application on the webpage that will allow you to generate a will that is for Nova Scotia. So Nova Scotia law. So they've been working on it for quite a few years. It is now set to actually be live in the spring. And so definitely check back, take a look at that. It's going to be something that, just like our personal directive application, you fill in the blanks, it generates a will and has a guide to walk you through those formalities. So this is more like that sort of typical will, or you hear people buying like will kits, that sort of thing. They're often for other jurisdictions. And because Nova Scotia has its own legislation, its own laws related to wills, this is really set up to work with that specific instruction that's needed in Nova Scotia. So it's going to be for really straightforward situations. You know, there's not a lot of complications or big assets. You know, it's for people who just need a very straightforward sort of will that pathway walks them through. So look out for that for the spring. And that's going to be that type of formal will. It'll have to have those same independent witnesses. It'll have to be in that same sort of formal way. Next slide. The second type of will that I'd mentioned that is also available in Nova Scotia is this more informal handwritten will. So in Nova Scotia, we actually have the ability to write a document wholly in our own hand. Us as the testator, we are the people writing it for ourselves, for our estates, and we sign the document at the end ourselves. That type of handwritten document doesn't need the same formalities that the other types of documents do when someone else is helping you prepare it. So a handwritten, sometimes they're called holograph wills. Those wills do not need witnesses. They are an excellent way for people to handle their estate. There are very few assets in an informal way, but it's going to be acceptable if you need to go to probate court, if it needs to be used with third parties. A handwritten will is going to be available to you to actually have something so that the person you name, your executor, your personal representative, can actually look after things for you. And so it's an informal way that's going to have a very low to zero cost, but it's going to be there for people who maybe, you know, you just rent an apartment and you have certain things you want to go to family members, But, common thing people say, I don't really have anything. I don't really have a lot. This is absolutely a great way to make sure you have something in place, because you can do it yourself independently. You can do it in your own handwriting, sign it, and you don't need to worry about the witnesses and the formalities and making sure you're appointing the right people and including the right security bonds and all kinds of other stuff that happens with formalities in a traditional sort of will. Next slide. And really, this all kind of focuses on a single point. Why do we do all this work about wills? The value of a will is that if we don't have a will, we're intestate. Intestacy is where a person dies without a valid will. And when a person passes and they don't have their wishes documented, they kind of think certain things are going to happen anyway. They kind of think, well, I'm already married, it's just going to go to my spouse. But we actually have something called the Intestate Succession Act here in Nova Scotia that does something differently than what we think it's going to do. What it does is it basically says, okay, if you're married or a registered domestic partner, if you have children, we're going to do this calculation. It doesn't all go to your spouse. Your spouse either has to elect the matrimonial home or $50,000. They have to do a form, they have to do an appraisal of the property, and then anything that's left over in your estate, well, that's going to be split between your spouse and however many children you have, okay? But then on top of that, we have something called the Matrimonial Property Act that says, hey, when someone passes away, you can request the property that you share with them be split 50-50. So then you have to wind back and deal with the matrimonial property division and then the intestate succession division. Depending on how many children you have, you may be dividing the estate into thirds and then the 2/3 spread amongst them. It gets very complicated. It's not the way people think it's going to work. And so intestacy is not going to operate the way a lot of people think it does. Next slide. The other main issue with intestacy is that common law couples are excluded from being able to deal with your estate. So the way the Intestate Succession Act is written in Nova Scotia, there's a specific list of who's eligible to apply to administer your estate. So instead of going to probate court for a grant of probate because you have a will, you go to probate court and say, they didn't have a will, but they have some stuff we need to disperse. There are beneficiaries, maybe there's some property, or maybe there's some checking accounts and savings accounts. And so this list of people goes to apply for a grant administration. It is a much longer and more expensive process than going to get a grant of probate. But also your common law spouses, doesn't matter if you've lived with them for 20 years, they are excluded from this list. So your creditors can apply before your common law spouse can. The only way to avoid this is having a will. Next slide. Protections are another key piece for being concerned about avoiding intestacy. So if you have adult children who maybe have vulnerabilities, you have an adult child that has a disability, receives government benefits, the gift you give them will impact the benefits they receive. And so there's something called a Henson Trust people will put into wills that basically provides a buffer so that if you want to leave, you want to leave a specific sort of amount that will be available to cover off things that happen in their lives that they may need help with time to time, but not impact their housing or their government benefits that they receive. You can set that up in your will. Similarly, if you have adult children that maybe have some addiction issues, financial problems, things like that, you can't plan for those with intestacy, but you can with a will. And so those sorts of protections are only available to put in place if you prepare a will in advance. Next slide. I mentioned briefly probate. So people say, okay, so I've got a will, great. Why do I need to go to probate? You may not need to go to probate court if you have a will. If you have a will and you held things in a variety of different ways with different people, or you're able to distribute your things without getting a court order, probate might not be necessary. Because really what probate is, it's that process where a court says, this is the true last will and testament of the deceased. We have checked it, we have approved it, and we've issued a court order. And so that court order provides the ability for you to go out into the community to deal with banks, the government, financial planners, all of the people, third parties out there, and say, hey, I have the authority to act. I have a grant of probate, and I'm going to administer the person's estate. And so probate court is really necessary when you have to deal with these other parties. So in a situation where, you know, you have a will or you don't have a will, probate court is there to basically go through the steps to give you authority to deal with whatever the deceased person has left in their estate. Next slide. So, for example, if a person passes away, but they actually hold their estate as joint tenants. So maybe you're joint bank account holders, you own your cottage property or your home as joint tenants with your spouse. The survivor in joint tenancy moves through and becomes the sole owner of property once a person, the other co-joint owner, passes away. So joint tenancy means I don't need a probate order in order to deal with my property because I hold it jointly with another person. Probate is required where you own something in just your name. It's only you that owns it. And so if you hold an asset solely in your own name, it's likely you're going to need to go to probate. If you have certain registered accounts, certain tax-free savings accounts, you can name a specific beneficiary or several beneficiaries to those specific individuals, and they will receive the actual amounts that are in those accounts without having to go through probate. Sometimes though, people don't check those designations, and it's actually still the estate that's listed as the designation, designated beneficiary, and it ends up, you need to go to probate in order to handle the asset. So there are a variety of reasons you'd need to potentially go to probate court to get an order, but not everyone's going to have to go to probate court. Next slide. Power of attorney. So the big bulk of what we're going to chat about in these next chunk of slides is powers of attorney. Power of attorney is the second document in the sort of basic Nova Scotia estate plan that is focused just totally 100% on financial decision-making, property decision-making. A power of attorney for many years was kind of mixed up with medical decision-making, but they changed the laws the last decade to really split those. You have someone who looks after your financial decisions. You have someone that looks after your medical. They may be the same person, but they're two very different roles. So your power of attorney is there to act in relation to financial decision-making, maybe because you're out of the country, or maybe because you're incapacitated. Something has happened. You've lost the ability to make decisions. You've named someone in an enduring power of attorney that will be able to act for you throughout your period of incapacity. So the big piece about a power of attorney is that it works with you while you're alive. And then when you pass away, it terminates automatically. And your will steps in, and whoever you've named as your executor, your personal directive in your will, then has the authority to make the decisions. But while you're alive, if they're different people, they have completely different responsibilities. The roles are different. So a power of attorney terminates on your passing when you die. Next slide. And what happens if we don't have a power of attorney? The only option we have in Nova Scotia is if you need some sort of authority to act on behalf of someone else, you need to go and get a court order under the Adult Capacity and Decision-Making Act. This is a long process. It requires quite a bit of paperwork. You see there a capacity assessment report, a representation plan. You need affidavits, you need an application, you need an order drafted. There's a lot that goes into it. And it's a bigger order. It's like it takes all of your power of attorney decisions and personal directive decisions and other decisions that kind of float around the edges and puts it into one order. That's why it has this representation plan. And it can involve many, many people making decisions. It is a very expensive and very necessary process for some people, but it can be avoided in almost all circumstances with a good power of attorney in place. Next slide. And what we've done in Nova Scotia is say, wow, okay, powers of attorney are becoming really important. People are finding themselves in situations where they're living longer, they may have different needs over many decades, and they may want to change their powers of attorney. They may want to create different sort of financial plans. They may just want someone to be able to pay their bills for them, and the bank is for whatever reason, a little wary of structuring their bank accounts in a certain way so that someone can pay the bills for them. A power of attorney has become really important. And as sort of these financial institutions and the governments get more and more strict, really having a power of attorney is the only way to have someone who's able to act for you if you can't do it all yourself. So the government basically acted on some really long-term plans that had been in process and proclaimed these changes to the Powers of Attorney Act in July of last year. So now the formalities of making a power of attorney match those as a will. So you have to have capacity, you have to know what you're doing, what's in the document. You have to have it in writing, you have to have it signed by you in front of two other independent witnesses. They've basically matched those requirements. Next slide. They've also really made some kind of radical changes that apply for powers of attorney that existed before July 2022. So if you've been acting as a power of attorney for the last number of years, these changes apply to you. The preparation of new powers of attorney have all these new formalities. If you have a power of attorney from before July of last year, it's still going to carry on. It's still going to be effective. It's still going to work. It is really a question of what is it that I'm going to be needing to do if I'm a power of attorney that has been acting for a number of years and I've been doing everything in a certain way, but stuff has sort of changed. What does that mean for me? That's what these changes are targeted at. The rules, the responsibilities, the obligations of someone acting under a power of attorney have increased. So if, for example, you write your power of attorney and you decide, I want to change it, or I want to make some difference to it. You now, as the person making the power of attorney, the donor, you need to actually advise those other people that you've removed in writing that they're no longer your power of attorney, right? When your power of attorney starts to act for you, you're going to have to notify certain people in writing. And I've kind of briefly included here some of the people you'll need to tell. There are certain circumstances where you need to tell even more people or different people. But the general idea in the new rules is that when you start to act as a power of attorney, you must say in writing to the donor. So that might be through the personal directive delegate. Hey, I'm going to be handling the financial decision-making now. Here's your notice for the donor because they've lost capacity and you are their delegate in the personal directive. You may need to tell a monitor. If it's a newer power of attorney, we're going to talk about what a monitor is. You may need to advise them in writing. You also may need to include notice to people who have specifically been listed in the power of attorney. So there's a very big range of people that you may now need to say in writing, hey, I'm the power of attorney, I have the document, I'm going to start paying the bills, I'm going to start filing the taxes, I'm going to start investing the funds. Next slide. The bigger piece that has kind of been there, but they've really made more detailed, is the piece about our responsibility if we're going to act as a power of attorney. We are bound by a duty of loyalty because it's a fiduciary relationship. It's this vulnerable person sort of relationship is the expectation. We have even more set out duties now for acting as a power of attorney. So of course we have to act in good faith. Of course we have to do what's in the donor's best interest, but we also need to make sure we're not taking a benefit for ourselves, that we're not in a conflict. If we're powers of attorney for more than 2 people, that we're very clear that we're not acting against one person's interest in favor of another. Next slide. Another change that's being fleshed out, and we're hoping future regulations that are expected to come down have a bit more info on this, because it's a really sort of big practical change for some people. The new section 5.2 basically says that we can no longer use a power of attorney to prevent personal contact with the donor. So it had been a worrying trend for the government and for courts that people were using a power of attorney to prevent certain individuals from being able to go to a nursing home or care center and hospital and have contact with the donor who may or may not have lost capacity. And so they've basically included the provision that you cannot really interfere with that relationship. The words they've used, we're waiting for a little more sort of detail on how that could practically work. But the words they're using are basically the same sort of words you see in sort of child custody or parenting time arrangements, right? So there's an expectation that if you have friends and family, supportive friends and family, that there should be an effort to allow contact, to support contact. Maybe you don't like that person. However, there's 3 or 4 other people who maybe work at the institution or who maybe are at the hospital or other family members who can get along fine and ensure that that contact takes place. Our Adult Capacity and Decision-Making Act gives us a bit of instruction on that too. For example, you cannot prevent people from contacting in this case, the person who's subject to the guardianship order. But similarly, the person who has made the power of attorney and is now, no longer able to act, you cannot interfere with them contacting family and friends or having those people reach out to them unless you can show it seriously jeopardizes the health and safety of them. So it's kind of bringing it more in line with this expectation that there was a lot of misuse. A lot of people were preventing access to family, and that's not going to be allowed underneath this financial power of attorney, which also just makes sense, right? This is a financial decision-making document. This is not to be getting involved with what should otherwise really be looked at in a more holistic way. And so they've removed that sort of all-powerful kind of clause that didn't exist in the last Power of Attorney Act, but had just been allowed to kind of grow because of people not being sure about where to look. Next slide. And another change, again, responding to a worry of what was happening to people's estates. If you're acting as a power of attorney, unless that power of attorney specifically says you can keep giving these gifts or give these things out each year or give this or that, you can't pre-gift what's in a will. Just because the person may have lost capacity and they will not be doing a new will, as a power of attorney, you cannot pre-gift those things. So even though, people might have, this was happening a lot with adult children, the person was going into care and then they sold the family home and then distributed it like the will had listed as though the person had already passed, right? That's very clearly now not allowed. The only way you can get rid of or dispose of an asset that is specifically a part of an estate plan is because the person needs the funds themselves. So the donor needs the money to pay for care or whatever it might be. And so in that case, their estate monies are used for their benefit. But that's another big change, kind of responding to people kind of pre-gifting to family and friends on the basis of, well, eventually the will give it to us anyway. Next slide. And the other big piece about accounting and focusing again more on the financial piece of a power of attorney is that there is a big update to Section 12 on record keeping, on accounting. So where a person specifically has named a power of attorney, in a power of attorney, someone to act with a monitor, without, we'll talk about monitors next. That person acting as a power of attorney that's given notice saying, hey, I'm the power of attorney for this person, I'm going to be acting. They need to keep specific records now. And we're also hoping to get a little more information on what that would look like because we have some examples in case law, but at the moment it's still very flexible. But the idea is if you're going to be acting as a power of attorney, you need to have a list of all of this person's assets, all of this person's debts, what personal property they maybe have registered in their name, what real property, what land do they have in their name? Are the property taxes being paid? How are they being paid? If you're writing checks, keeping canceled copies or statements from the banks, keeping documents together. There is a big accounting role now for powers of attorney that will be sort of rolled out and explained in more detail over the next, it's going to be several years because people were used to doing things in a certain way. At the very least, if someone's going to be acting as a power of attorney, they should at the very least have some sort of journal, calendar, accounting, even if it's not, you know, it doesn't have to be an Excel spreadsheet at the moment, but making sure that they're keeping track on this date, I spent $50 at this location for this purpose of the donor, right? I topped up their account at the nursing home or senior center, $200 on this date for personal care. Keeping track of when that person's money is spent is going to be really important because so far in the cases, as long as an attorney could show that they kept as good records as possible and the money was spent on the donor, they have been treated pretty kindly by the courts. The cases where the power of attorney is treated quite harshly because a power of attorney's personal things, personal assets can be taken if they're found to have acted outside of their authority, right? So the idea is courts want to get tougher with people who look like they may not be keeping good track and following through is because there's so many examples they've seen, you know, Nova Scotia liquor store. Well, the person has been in care and not, has not celebrated anything for many years. And there's purchase after purchase on their accounts related to those amounts. Those sorts of things they're going to get much more serious about. And this legislative change makes it more available to the court to get involved and to basically set out some expectations if you're going to act. Next slide. And we come to the role of monitor. So a monitor is basically someone you can name now in your power of attorney that has some sort of specific powers. So a monitor is someone that can always sort of communicate with you. They can always take your questions to the attorney and act on your behalf as a go-between. They can ask questions for you. If they're named in your power of attorney, they can help with decision-making. They can focus on asking questions about how your estate's being looked after, how you're being looked after. Are your bills being paid? Are your medical supports being provided? Is that bill being covered? asking for accounting. They can ask for those records that the attorney has to keep in detail, and they can even represent you in court. So if there's a question, they can fill out the paperwork and go and get time in front of a judge to say, hey, I was appointed as monitor. I've asked for these records twice. They're not giving them to me. And that person, along with those costs, that attorney and those costs are gonna be expected to be met in court. So it's a sort of a big buffer role that we didn't really see in Nova Scotia. And it's basically been put into the law to say to people, hey, maybe this person is not going to do all of the hard, heavy lifting of being a power of attorney. But if you trust them and there's some questions you may have from time to time, this monitor can be that person for you to act and ask questions. Next slide. And the third document, and I believe Caregivers Nova Scotia has some excellent information and maybe even some samples for personal directives, hey? And I'm not sure if there's going to be any of that introduced after I'm finished talking, but I know that Caregivers Nova Scotia has done a lot of work related to Personal Directives Act. The personal directive is really the medical decision-making document. So a personal directive is triggered when you can no longer speak to the physicians, to the nurses, and tell them what you need or want. A personal directive names someone in advance, a delegate, who is able to speak for you and should know what you do or don't want. And so a personal directive can be as detailed or as general as you may wish. It's very flexible. It doesn't have the same formalities that you're going to see in the will and the power of attorney. You need to have one witness instead of two. As long as it's not the person you name to act as your delegate, you're going to be fine with the formalities. And the government of Nova Scotia has some excellent examples and listens as well. If you go to the next slide. That's a really tiny screenshot. Listens has on the website a basically fill in the blank, answer questions. It'll generate a personal directive for you with some info on how to have it signed and where to share it, where to keep it, etc., on our legalinfo.org website as well. Personal directives are really great to have available in so many circumstances. I mean, I tell young people all the time, do you go skating? The number of people I have worked with who've had concussions skating in their 20s and 30s. And for a period of time, they had some real issues and who was going to be acting for them and answering questions. And, maybe they were with a long-term girlfriend, but not with, not living at home. But, this personal directive, making these sort of medical decisions, appointing someone to act for you, just like with a power of attorney, they're so important while we're alive. Having someone to assist us, having that paperwork available, thinking about it, talking about it in advance, so very, very, very important. This is free. This is available. I believe Caregivers Nova Scotia as well has some info that they may be sharing. Next slide. If you have any feedback or you have any specific questions we don't get to today, feel free to shoot us an email at registration@legalinfo.org. And I think there's maybe just one or two more. Legalinfo.org, that's our website that you can access the charities info. And there's just a couple of links there. The Canadian Legal Info Institute has a whole bunch of commentary and info on the laws. And then our court's website and family law website have a lot of forms, information about probate, a lot of pamphlets that they've prepared as well. And I think that's about it for me. That's a whole bunch of legislation that applies. Do your wills, do your powers of attorney, do your personal directives. That's all you really need from that slide. And thank you.